Good afternoon. May it please the court, my name is Erin Newell, and I represent the appellants VTI Group and Shauna Vercher. This is a case where the jury got carried away trying to give relief to a very sympathetic figure in Mr. Donahue in the absence of evidence supporting his claims for relief. It's the appellant's position that the court's errors of law are most apparent in Mr. Donahue's claims for tortious interference with the business relationship, so I'd like to start there. In Mr. Donahue's pleadings, he failed to allege all four elements of the tortious interference with the business relationship. The first element is the existence of a business relationship. The law is very clear across the state that there has to be an identifiable entity. An allegation of just a group of potential customers is not sufficient. And when we got to the trial stage, unfortunately, this did get past pleading, though it should not have. When it got to the trial stage, this evidentiary inadequacy was not cured. There was no further evidence of any specifically identifiable business relationship. Mr. Donahue did testify to a publisher. That publisher was not named. This phantom publisher would not suffice to meet the requirements set forth by the Florida Supreme Court in Ferguson. Specifically in Ferguson, that plaintiff alleged there was a group of people that were apparently going to do business with him. He didn't name any of those individuals. He didn't have any sort of contractual agreements, no orders that were coming in, no evidence of an actual business relationship that would have come to fruition had there not been an interference. And that's just element number one, Your Honors. If we move on to the next three elements of tortious interference with a business relationship, the inadequacies are even worse. There's no allegation that VTI or Vercher had any knowledge of any business relationship on the part of the defendant. At trial, there's no evidence. Mr. Donahue doesn't offer any documentary support. He doesn't testify that he made VTI or Mrs. Vercher aware that he had these forthcoming sales of his, quote, new book.
Although you couch your argument in terms of pleading defects.
Yes.
You are also saying, are you not, that there was not adequate proof at trial?
Exactly, Your Honor. And the fact of the matter is, unfortunately, it did make it to trial, though it's our position it should have been dismissed.
Having made it to trial, you are also saying he didn't fill those gaps in with evidence.
Exactly. The appellants do recognize that the Florida Rules of Procedure would allow the pleadings to be amended to conform with the evidence, or if there was a trial of those additional fact issues by implied or direct consent. But that's not the case here. There was no evidence. They didn't go on and cure those defects in trial by providing that evidence. So there's no evidence of the first element, the existence of a business relationship. The second element, knowledge of the relationship. The third element, intentional and unjustified interference. And this goes to causation as well. There has to be evidence that VTI or Mrs. Vercher actually interfered, did something directly to interfere with these phantom publishing deals. There simply is none. And lastly, damages. The mere future expectation that he may sell some more books or he may make a movie is simply not enough. There's no movie deal, there's no documentary support. This claim should never have reached the jury. Moving on to the next claim that the appellant believes there were very bad errors of law is the intentional infliction of emotional distress claim. Now, the same pleading deficiencies are present in this claim, taking all of the pleadings as true, as we must do when we're looking at a motion to dismiss. Really, the most that Mr. Donahue alleged was that VTI and or Mrs. Vercher were withholding money due to him under the contract or misappropriating that money, even defrauding him. These things are not sufficiently outrageous as a matter of law. Florida courts have spoken on these issues.
How about the website?
That would be moving on to defamatory statements, things in that nature. And, Your Honor, in Valdez, the 3rd District spoke directly to this. statements that may be defamatory are not going to be sufficiently outrageous as a matter of law. This has to go beyond the bounds of all decent society. If we look at the testimony that actually was offered in trial, moving on to the trial stage and the evidence that was presented, although this is a matter of law, which Your Honors of course know, that there was nothing that really struck the chord of this should not be on the internet. This is outrageous as a matter of law. If we look at Sadie, which is actually a federal court from the Middle District, that's very factually similar. There were allegations published on social media by the defendant that the plaintiff was immoral, that he wasn't acting correctly, wasn't acting professionally. Those type of allegations are not sufficient as a matter of law to constitute outrageous behavior. Therefore, that element of intentional infliction of emotional distress has to fail. It wasn't cured during trial. And even so, even putting aside that element, let's say that these were outrageous as a matter of law. The majority of acts that Mr. Donaghy focused on were the misappropriation of funds or the defrauding of Mr. Donaghy by VTI or Virture. And we will get into this later, but quite frankly, VTI was authorized to treat Mr. Donaghy's potential profit as it did under the terms of the contract. There was no specific contractual obligation for VTI to create a separate escrow account or some other separate identifiable fund in which Mr. Donaghy's potential profits had to live and had to not be touched. So this actually, under Baker, is privileged when we're talking about intentional infliction of emotional distress, the misappropriation of funds, because it was authorized by the contract. Moving on, there is also, for intentional infliction of emotional distress, the requirement that there be proximate causation of severe distress. When we look at the severe distress standard, this is a reasonable man objective standard. It is also a matter of law. So we have to look at this in context. What was going on with Mr. Donaghy at the time? He had just come off of the criminal arrest, and he had served his time in prison. He was coming out, and at most, he alleges that, and testifies to, that discovering the website caused him distress. The nature of his relationship with VTI and Virture, the disputes that they were having in dissolving their contract, caused him emotional distress, and the decline in sales of his book caused him emotional distress. None of these things would be so much as to cause the court to interfere, and I am going to refer, if Your Honors will bear with me, to the exact standards set out by the restatement of torts, because I think it's really poignant on this issue. And now that I skipped it. The law intervenes only where the distress inflicted is so severe that the reasonable man could not be expected to endure it. The reasonable man can be expected to endure seeing unflattering things about himself on the internet, disagreeing with his publisher, and having a decline in sales and books. It's unfortunate that, this particular standard is so high, and it is in Florida. Florida courts acknowledge that. However, that is the standard, and legally speaking, these claims should never have reached the jury. Moving on to his other claims. Yes.
As Mr. Donaghy testified during the trial, that his concern about having his parole or probation violated in return to prison caused him any distress?
He does discuss concern over his parole. However, I don't believe that it was in terms of the emotional distress claim. I believe it was more in terms of the, to be quite honest, Your Honor, I'm not sure what claim he was trying to get at there, but let me refer to that testimony in the record.
I'm not trying to take up all your time.
That's okay. I do believe, Your Honor, and I will perhaps get back to this, I did neglect to reserve 3 minutes of rebuttal. I apologize. Thank you.
Too late, I'm sorry.
Too late. But I will in fact get back to that. I won't forget you, Judge Casanueva. Okay. Moving on to the civil theft. Insufficient pleading. Here we have a very statutory situation. The elements are laid out by the statute. There has to be a cognizable property interest of another. Those definitions are set forth in the statute, section 812.012, subsection 4s and 5.
How about his, I I know the briefs have concentrated on the money
Yes.
per se, the money that
The
has been
identity of the
received
money.
by VTI.
Mm-hmm.
But how about his intellectual property right? Isn't there a suggestion that the VTI continued to sell the book even after the relationship had been terminated?
Property, as defined by the statute, would include an intellectual property right, Your Honor. However, that's a good question. I hadn't thought of that. The allegations and the evidence that came out did not necessarily discuss the theft of the book. However, I will say, in Mr. Donahue's testimony, he did admit that he did not know who was selling the book online, that they tried to investigate it, but they couldn't actually figure out.
So there was no evidence that it was VTI?
Exactly.
Or Ms. Vircher?
Right, they were not able to identify who the online vendors of the book were. So that couldn't be attributed under the civil theft statute to Mrs. Vircher or VTI. Moving on to the actual evidence at trial, this is a clear and convincing standard. Again, the money simply had no separate character. It can't form the basis of a theft claim. That's Gasparini. Gasparini, the 3rd District Court of Appeal case. Directed verdict was granted because of that specific insufficiency in the evidence. Also, the felonious intent of taking has to be at the time of the taking. The evidence is very muddied on this issue. It's not clear and convincing. There's no point in time where Mr. Donahue was able to prove that Mrs. Vircher or VTI decided to take a specifically identifiable sum or item from Mr. Donahue. And finally, there's the specific intent, there's the causation element of civil theft. Here, really the evidence shows it was the unfortunate excess of expenses over revenue that caused Mr. Donahue to lose that potential profit. Mr. Donahue didn't offer any evidence that it was in fact Ms. Vircher or Mrs. Vircher or VTI's actions that caused him to lose those profits, specifically his profits. And I will highlight that word. The word profits becomes very important when we look at the breach of contract action. And we do allege that there was insufficient evidence of damages. That is the 3rd element of the breach of contract action. And it is axiomatic that the plaintiff must prove damages, a specific sum of damages. Any notion that Mr. Donahue didn't have to prove expenses is ludicrous in the appellant's position, because the contract specifically identifies profit as revenues less expenses. Moreover, the modified contract of December 14th, 2009 lists expenses to be used when, quote, calculating profit. So the notion that Mr. Donahue could have come to any conclusion as to damages without addressing the expenses issue is simply not reasonable. Without that evidence, the jury could not in fact determine whether there had been a breach, because it could not determine what the amount of profit actually was, as defined by the terms of the contract. Finally, I want to address the conspiracy to commit civil theft. The pleading is insufficient because there's no allegation of actionable wrong, and that's the 3rd District's opinion in Balcour is very specific about there needed to be a cause of action that 2 or more persons engaged in. At trial, the evidence was not sufficient. In fact, there's no actual conspirators that were proven at trial. An agent cannot conspire with his or her employer. VTI employed each and every single person that Mr. Donahue tried to offer to the jury as conspirators. According to Dickerson, which is a federal court case, but they do cite to Florida State Court precedent, they can't be conspirators as a matter of law. The only individual that could have been a conspirator as a matter of law was Mr. Vircher. If we look at Mr. Vircher, there may have been 3 lines of testimony regarding his role in this whole conglomerate of events. And quite frankly, if we look at a case like Donofrio, where the conspirator was really involved in the conspiracy, he knew what was going on. He actually profited from the conspiracy. It was regarding real estate, and he actually profited from the loss of this real estate in Donofrio. Here, Mr. Vercher is simply, according to Mrs. Vercher's testimony, stopping by to drop off pizza at the office with his daughter. How that can be evidence of knowing and intentional assistance in this alleged conspiracy, it's not. It's not reasonable. There was nothing there for the jury to actually find liability for conspiracy to commit civil theft. I will go ahead and rest on those issues because we do believe those issues of law constitute and in fact require reversal of this verdict. Thank you.
Thank you, Ms. Neal. You have about 4.5 minutes left.
May it please the court, your honors, Brooks Rathett on behalf of the appellee, Mr. Donaghy. Your honors, one issue that was obvious was that much of the argument made by appellant is a lot about weighing of the evidence. There wasn't enough evidence of this. There wasn't enough evidence of this to the jury. The jury couldn't have found this. The jury could not have found that. It's a lot of suggestion, if not explicit, but implicitly saying, if you weighed this evidence, the verdict was a bad verdict. That's not the standard for motion to dismiss, not the standard for directed verdict, not the proper standard in this case. And what's most interesting about that aspect of the weighing is almost a complete reversal on appeal of the appellant's position with what kind of case this was. And what I mean by that is the appellant, for all intents and purposes at trial, agreed that there was theft, agreed that Mr. Donaghy's fruits of his labor, his story was his property, and that's what was valuable, was his story. That all the fruits of that were taken from him, that people conspired to take it from him, that people acted outrageously toward him. The appellant at trial agreed with all of that. The only distinction at trial was they pointed the finger at someone else. VTI agreed. VTI said one of its employees did all these things to Mr. Donaghy. All these things that now appellant says Mr. Donaghy has no claim. They agreed he did have a claim, but they pointed the finger at Ms. LaFontaine. That was the target. That was the wrongdoer to them. But they never disputed the wrongdoing. They only disputed the wrongdoer. Now only on appeal are they saying, oh, there was never any wrongdoing. But they attacked the wrongdoer, and that was for the jury. Ms. LaFontaine testified, Ms. Vercher testified, Mr. Donaghy testified, all the evidence. And Ms. Vercher put on evidence. Ms. Vercher put on evidence of theft and of wrongdoing and of improper behavior to attack Ms. LaFontaine, to point the finger at her. And the jury just didn't believe that. They didn't agree that Ms. LaFontaine did anything wrong to Mr. Donaghy. They thought that the person at VTI, everyone agreed it was VTI, whether it was Ms. LaFontaine or Ms. Vercher, it was VTI. Even the appellant agreed to that when they pointed the finger at Ms. LaFontaine. The question was, who at VTI was the responsible person? And the jury found that to be Ms. Vercher. Now, with respect to Ms. Vercher's actions, the intentional infliction of emotional distress, you can't take it out of the context of the case at trial. I understand there are objective standards in intentional infliction. Outrageousness is an issue of law, whether something rises to the level of outrageousness. Agreed. But you still can't take everything out of context of the situation in this case. Mr. Donaghy's history of having been, and he owned it, he owned up to it, of wrongdoing in the past and of criminal behavior. And in that context, anything done to find that pressure point on him, to find that vulnerability in his history, and to press it, and to use it against him, is outrageous. And that's what happened here. The evidence before this jury, Ms. Vercher's testimony, Ms. LaFontaine's testimony, Mr. Donaghy's testimony, was there were attempts by Ms. Vercher to interfere with his parole. If that's alone to a jury would clearly be outrageous and objectively outrageous to get in the middle of one's relationship with their parole officer. Think about the burden and the fear that places on a human being who's been convicted and now has accusations made to a parole officer. This isn't about defamation and just saying something untrue about someone that hurts their reputation. This is about getting in the middle of legal relationships with someone who can Have you incarcerated? Very serious things. Interfering with his relationship with his ex-wife. He testified about that, about Ms. Vercher telling his ex-wife things about him threatening people, which led to his ex-wife fighting with him about access to children. Was that weighty enough? That was up for the jury. Did that convince the jury? We think it ultimately did. But that was a weight issue. But that was there. That was evidence presented to them. These actions of interfering with the ex-wife, of interfering with parole officer, of interfering with the U.S. Department of Justice and getting involved in that. And the entire thing of knowing he's vulnerable because he's got to pay restitution based on his past criminality, that the fruits of his story go toward that and will help him rebuild his life, to conspire and to come up with a plan to steal that money, and that's what the jury found was done here, to steal that money from Mr. Donaghy is outrageous. To create a blog, not just to comment about people, this isn't getting on the website or getting on talk radio and commenting about someone. This is the creation of a blog with the sole purpose to undermine and demean and attack someone's reputation in order to effectuate your bigger plan, which was to use the fruits of his story for your own benefit. That's outrageous. All these actions were clearly outrageous, and the jury agreed with that. The breach of contract issue, again, don't want to belabor it because at the trial level, there were clearly, based on the presentation of the evidence from the defense themselves, an agreement that there was a breach of contract. I mean, he was owed money, and he didn't get it. So the issue is that expenses issue. And I think that is an important issue to address, because there was clearly evidence of a breach, and there was clearly evidence of damages, the amount being the $244,000 some odd dollars of revenues from the sale of the book. So the question is the expense.
That was revenue.
Correct, yes. So the question is the expenses issue. But what makes this interesting, it's not your typical lost profits type of expenses case where, first of all, where you have to surmise perhaps what future lost profits are in a business. That's not here. We have a specific figure. So that's different than that case law. But you're right. Let's say you have expenses. You have to deduct those. The problem is, in most of those cases with profit and expenses, you're talking about the profit and expenses of an overall business enterprise. And it's all one unit, and it's easy to determine. You say the business made this much money, the business spent this much money. Here, we sort of have a quasi-spoliation type issue created by the appellant herself, because in making it impossible to determine the expenses attributable to the contract duties owed to Mr. Donaghy, not the expenses of VTI. See, that would be your typical case law, is what were the expenses of VTI? But here there had to be discerning what were the expenses of VTI attributable to the promotion, marketing, and sale of Mr. Donaghy's books. And the evidence in this case was that VTI made that impossible for anyone to determine. That's sort of a spoliation type thing. Mr. Donaghy cannot meet a burden that's impossible to meet. No one could differentiate those, and we know from the evidence to the U.S., even the U.S. Department of Justice said, we can't tell, you're sending us, we need you to send us restitution money. This is what Mr. Donaghy wanted to find out where his money's going. Send us restitution money, include your expenses. And they didn't do that. They didn't do that for the U.S. Department of Justice. They didn't do that for Mr. Donaghy when he requested it. He wrote a letter, let's settle up. I want to see the expenses. What are the expenses attributable to me? We don't have that. Instead, we have evidence of the taking of Mr. Donaghy's fruits of his story and spending them on things that are clearly not related to Mr. Donaghy. Trips, business trips, other projects, bonuses for people, starting up websites to attack Mr. Donaghy, all these other uses of the money, all intermingled, all commingled, making it impossible to meet that standard. And you can't then use that as a sword and a shield. We're going to take your money, commingle it, spend it on ourselves, and then say you can't prove how we spent your money. And that was the problem with expenses here. And there was an expert for Mr. Donaghy who did testify. Yes, I can't tell because the bookkeeping is so shoddy, it's impossible to do this, so I'm going to go with the number that we have that is discernible. And the jury was left with the assumption that the expenses, whatever expenses VTI had, they were spent on other things, not on behalf of Mr. Donaghy. And there was no testimony from Ms. Vircher, who had the opportunity to testify as to what was spent on Mr. Donaghy.
So the number the jury gave was the revenue number, was
It was. Yes, that's
The
correct.
jury did not deduct any expenses.
Did not.
Even given what your expert said about what might have been reasonably expected.
Correct. That's correct, Your Honor. The tortious interference claim, there was an attack on the tortious interference claim, and like Your Honors, I think, pointed out, there were sales made after the termination of the contract, continued sales, and again, it's Ms. Vircher who was the promoter and the marketer. She is the one who has...
What was the evidence, though, that it was, and you're talking, there were online sales after the relationship was terminated.
Right, there were...
What was the evidence that this was VTI or Ms. Vircher doing this?
Mr. Donaghy testified that it was his understanding that there was no independent other party or witness to testify that they were buying it from VTI, but she was the one who was promoting and marketing the book. She was the one who was out there selling them after the fact, right? And Mr. Donaghy testified that that's the only person who would be doing that because that was her role, and she was continuing to do that. And then when he testified that he had another publisher. Now, again, this is credibility. The jury could have rejected it, could have believed Mr. Donaghy. They chose to believe him. That's a credibility issue. They're attacking that the evidence wasn't good enough. That's not the same as saying all inferences in a light most favorable to Mr. Donaghy didn't show that when he testified, I had another publisher. That publisher told me I can't do the book deal with you because of Ms. Vircher's actions and what she's saying about you. And he said, I talked to a producer about getting involved with movie rights. I can't talk with you because of what Ms. Vircher's doing. That was Mr. Donaghy's testimony, and the jury found it credible and believable, and they didn't find Ms. Vircher to be credible and believable.
Was there a hearsay objection to any of that testimony?
Not on the record, Your Honor, no, it was not. And there were a lot of things that were not objected to on the record that are now becoming issues here, particularly some of the other items that appellant argued about were unfairness in the closing arguments, for example, and I just want to point out, this was not a case where there was an attack on Ms. Vircher's character as such, as just whole cloth, let's attack this woman's character. In fact, it's the opposite of what that case law says, where you can't say that 5 years ago Ms. Vircher did something really bad, and I'm going to tell the jury about that. It has nothing to do with this case. Every issue dealing with her character, every presentation to the jury dealing with her character was related to her actions in this case. They were all related throughout the course of the trial to closing. It was, she did bad things, her character should be questioned because of what she did to Mr. Donaghy. That's a huge distinction, just complaining, well, you attacked her character. Well, of course, in an intentional infliction of emotional distress claim, or a civil theft claim when someone's stealing from someone, or when you're conspiring with your employees and others, former employees, to hurt Mr. Donaghy and to take his money, character is going to come into question. And I note that in the closing arguments, there were a couple objections raised and were sustained against Appellee. There were 5 objections raised by the appellee against the appellant, and all 5 were sustained for similar reasons, attacking Mr. Donaghy, talking about things like that. So, on balance, both sides questioned the credibility, and particularly in this case, the main attack was against Ms. LaFontaine. That's really what this was. This trial became a trial of, it was almost stipulated. Members of the jury, someone stole from Mr. Donaghy. Someone took his money. People sold books and made money off those books, and that money went elsewhere. And it went into this account, that account, these people's travels, this thing. We say Ms. Vircher did it. Ms. Vircher says Ms. LaFontaine did it. You decide which one of those two did it on behalf of VTI. And the jury made its decision. And they weighed the evidence, and the court affirmed that, allowed that to stand, and I ask that Your Honors affirm that as well. Thank you.
Thank you.
So I'd like to go back to a question that Judge Casanueva had posed about whether Donaghy testified as to the effect of being afraid to be taken off of parole. I did refer back into the trial transcript, and really where he's testifying about the emotional distress he suffered occurs at pages 1057 to 1058 of the record transcript, and there's no specificity as to what particularly was causing him anything. Also, I want to mention, he says that he went to a psychiatrist at some point, took some identified medication, and had, unfortunately, problems with his family, but there's no specific dates, there's no link as to proximate causation between what was causing these issues. Do recall that he had gone through a lot with his incarceration prior to having these really very minor problems in comparison with Mrs. Vercher and VTI. Next, I want to address the appellee's argument. The appellants aren't saying the evidence wasn't good enough. We're saying it wasn't presented at all.
Well, one of the things he said, which was intriguing to me, he says that your whole strategy here is dramatically different than it was below. He said below it was all this stuff happened, but someone else did it. Here your strategy is none of this stuff happened, there was no proof of it. So that's a little troubling to me. I mean, were there any challenges in the record below to some of the things that you're now raising on appeal, or is this all sort of a brand new argument?
Your Honor, you anticipated me. I was going to address that next. There was no specific position where we made an affirmative defense that this wasn't our action, this wasn't Mrs. Vercher's action, this was Mrs. LaFontaine's action. To the contrary, Mrs. Vercher, and there is testimony to this, she did file a criminal complaint against Mrs. LaFontaine. In her layman opinion, Mrs. LaFontaine had stolen funds. That is an entirely different issue as to what the law requires in pleading a civil theft. There is no such thing as almost stipulated to. There was no stipulation that there was a theft in this case. It has always been the appellant's position that the property interest being alleged is not an identifiable sum. It's always been the appellant's position that, in fact, Mr. Donaghy failed to prove what sum it is that he is going after. I want to also comment on the issue with the breach of contract. There can be no breach of contract if there's no identifiable sum. There's no damages. What damages specifically did VTI, not pay to Mr. Donaghy? And I do want to recall a case out of the 5th District. There was clearly expenses in this case. If you look at the Department of Justice, they found expenses. Mrs. Vercher paid 15% of the total profit the Department of Justice deemed appropriate for Mr. Donaghy. She paid some $7,000. That's 15% of $51,000 due to Mr. Donaghy. That represents 73% of the profit. Clearly in the record, the documentary evidence shows that the Department of Justice requested subpoena ducis tecum for Mrs. Vercher to produce evidence of expenses. Paragraph 12 of that. Those were produced. At first they were redacted copies, but on further prodding, they were unredacted copies. So that evidence existed. And also, this spoliation shade that there's almost spoliation. There is no almost spoliation. It's either intentional or it's not. There was no complaint at any point below by Mr. Donaghy that Mrs. Vercher's production was inadequate under the rules of civil procedure. That is the appropriate vehicle to deal with a litigant who is not being forthcoming with expenses, not trial to avoid your burden of proof. That being said, the appellant requests that this court reverse the verdict in all respects for inadequate evidence, and I will recall before I leave you all that if your honors are not inclined to do so, there are the evidentiary issues that do constitute an abuse of discretion, and they do warrant reversal for new trial as well.
Okay.
Thank you.
Ms. Neal. Thank you both.
Thank you. You allowed to?
I'm sorry?
Are you allowed to? I didn't hear you, Your Honor.
I said thank you both.
Oh, thank you. Okay.